Okay, so getting a refusal on your refugee claim, that is an incredibly difficult moment, and it can really feel like the end of the road. But I want to tell you, it's not. In this explainer, I'm going to give you a clear, calm, and really actionable guide for exactly what to do next.
And this right here, this is the single most important thing you need to hold on to right now. A no is a critical turning point, for sure. It's a crossroads, but it is not a final destination. There are very clear pathways forward, and understanding them is your first step to taking back control of your situation. So here's our game plan. We're going to walk through this together, step by step. We'll start by really cementing why a refusal isn't the end. Then we'll look at your 2 appeal pathways, figure out your eligibility, and then lay out a concrete 45-day action plan. And we'll finish up by looking at why claims get refused, because that's going to help you build a much stronger case. Okay, let's dive. All right, so the moment you get that refusal, you need to understand something right away. A clock has just started ticking. The situation is definitely urgent, but it is absolutely manageable if you act fast. So, what's happening behind the scenes? Well, that letter from the Refugee Protection Division, the RPD, it flips a switch. It activates something called a conditional removal order. In simple terms, this means the order for you to leave Canada is now technically in effect. But the key word here, the one to focus on, is conditional. It can be paused. Now, I want you to burn this number into your brain. 15. You have exactly 15 calendar days from the moment you get that written decision to file what's called a notice of appeal. Not business days, 15 calendar days. And trust me, this deadline is absolute. And here's the good news, the ray of light in all of this. Filing that notice of appeal within those 15 days gives you immediate protection. It automatically puts your removal order on hold. The legal term is that it stays the order. This means you cannot be removed from Canada while the appeal division is looking at your case. Okay, so you've got this ticking clock, but you also have a way to pause it. The question is, how? Well, after a refusal, you have 2 potential legal pathways to challenge that decision, and choosing the right one is absolutely critical. Let's break this down, because it's like a fork in the road. On one side, you have the most common route, an appeal to the Refugee Appeal Division, or what everyone calls the RAD. This is a full-on review of your case to see if the first decision-maker made errors in law or in the facts. The RAD has real power. They can completely overturn the refusal and grant you status. The other path is a judicial review at the federal court. Now, this is different. It's not an appeal of the facts, but a review of the process to make sure it was fair. A judge here can't give you status, but they can order a do-over, sending your case back for a brand new hearing. This is the path for people who, for specific reasons, can't go to the RAD. So, before we go any farther, we have to figure out that first big question. Are you even eligible for that main pathway, the Refugee Appeal Division? Let's figure this out right now. The good news is most claimants are eligible, but there are some really specific exceptions that could block you from using the RAD. This is where you need to become a detective with your refusal documents. Seriously, read them very carefully and look for these exact phrases. You are barred from a RAD appeal and have to go to federal court if the decision says your claim has no credible basis. Other red flags are if you entered Canada under an exception to the Safe Third Country Agreement, if you've ever withdrawn or abandoned a claim in the past, or if your arrival was called a designated irregular arrival. If you see any of these phrases, your path is the federal court, not the RAD. Okay, so let's assume you are eligible for the RAD. Now what? Well, from this point on, you are on a very clear, very strict timeline. Everything important happens inside this 45-day window. Let's walk through your timeline, step by step. First, days 1 through 5, you absolutely must talk to a legal professional. An experienced lawyer or consultant needs time to review your file. Next, by day 15, that notice of appeal has to be filed. No excuses. Then, a new clock starts. You get 30 more days, so 45 days total from the start, to submit your full appeal. This is called perfecting the appeal. It means filing your appellant's record, which is the big package with all your legal arguments and any new evidence you have. After that's in, you wait for the RAD's decision. All right, let's talk about the practical stuff for a second. The money and the time. Take a look here. Notice anything? There is no government fee to file a RAD appeal. 0. Now, you'll have professional fees for your lawyer or consultant, of course. Processing usually takes about 6 to 12 months. And here's another important piece of good news. Renewing your work permit while you're appealing is also free of government fees. You know, if you want to build a really strong appeal, you first have to understand exactly why your claim was refused in the first place. The answer is right there in your refusal letter. Now, usually it boils down to one of three common reasons. Your appeal has to directly tackle whichever one is in your letter. First up is the internal flight alternative, or IFA. This just means the officer decided that, yeah, maybe you're in danger in your hometown, but you could have just moved to another city in your own country and been fine. Your appeal needs to prove why that wasn't a safe or reasonable option. Second, and this is a big one, are credibility issues. This happens when the officer thinks they found contradictions in your story. This can happen for so many reasons. Trauma messes with your memory. Things get lost in translation. An appeal here has to explain those seeming discrepancies. And third, there's state protection. This is when the officer thinks you should have gone to the police in your country first. A strong appeal shows why that was impossible or would have been useless.
Okay, let's pause for a second and address a huge, practical question that I know is on your mind. Can you keep working? Can you still support yourself and your family while all this is going on?
And the answer, thankfully, is yes, absolutely. As long as you file that appeal on time, your legal status as a claimant continues. You can go ahead and apply to renew your work permit and keep working legally while you wait for the decision. I know I've mentioned it before, but we have to circle back to that 15-day deadline one last time because it is that important. What actually happens if you miss it?
And look, there is no way to sugarcoat this. The reality is, it's game over for the appeal. If you miss that 15-day deadline, you lose your right to appeal to the raid. It's just gone. Your removal order becomes final, it becomes enforceable, and the Canada Border Services Agency will start the process to have you deported. Okay, so let's boil this all down to the key takeaways, the things you absolutely need to remember. First, a refusal is not a final defeat. It's a signal that you need to act, and act now. Second, that 15-day deadline to file your appeal is absolute, non-negotiable. It's your top priority. Third, remember that filing the appeal is your shield. It pauses your removal from Canada. And finally, and this is so important, don't try to do this alone. Get an urgent consultation with an experienced immigration lawyer or a licensed consultant to figure out your best path forward.
Look, I know this is a challenging, stressful moment, but it's a moment with a path forward. The system has these avenues for review built into it, and knowing how they work is your greatest strength right now. Your journey has hit a serious obstacle, for sure, but it is not over. The only question now is, are you ready to take that next crucial step?